Justices of the Supreme Court of the State of Iowa, hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Please be seated, everyone. We are here this afternoon for the submission of 3 cases. The case of Den Hartog Industries versus Dungan is hereby submitted without oral argument. Our first oral argument of the afternoon is State versus Mahana. Ms. Ruhtenberg, you may begin.
Thank you, Your Honor. May it please the court, counsel. Good afternoon. My name is Maria Ruhtenberg. I represent the defendant, Austin Mahana, today. Mr. Mahana was, in 2018, convicted of carrying weapons because he was pulled over in a traffic violation. He informed the officer he had a firearm in his car. At the time, that was an aggravated misdemeanor under our code. He was arrested and later, he was convicted. In 2021, 3 years later, the code was changed. That particular crime is no longer a crime in Iowa. However, under our felon in possession of a firearm law, that crime is included as a felony because it is a firearm violation that carries more than 1 year in prison. So he was informed later that he was not allowed to carry a firearm, and because he qualified under our prohibition statute. He was later then arrested and charged with the violation of that statute, and we're here today to argue that that is unconstitutional under the Second Amendment of the federal Constitution and also under the Iowa Constitution. So to begin with, I'll address the Second Amendment. The first question is, does the Second Amendment apply to Mr. Mahana? We argue that it certainly does. He is under the United States Supreme Court case, Bruin and others. He is of the people. He is a citizen and has the right to go armed. And the actions that he was arrested for back in 2018 would no doubt be protected constitutionally under Bruin had that happened afterwards. Because he was not doing anything violent, he was not participating in any violent crime, he was simply going armed for self-defense.
Well, I mean, if he had a license, that would have been a defense back in, a permit, excuse me, that would have been a defense in 2018, correct?
If he had a permit, he would have been, yes.
So,
Remember if, in his particular case, I think he had a loaded weapon. There might have been some regulations about where and in what manner you could have carried the weapon. So yeah.
and the Supreme Court has generally said, I mean, they haven't decided the issue squarely, but they've generally been saying that licensing, permitting laws are okay as long as there shall license laws, not as opposed to ones like the law in Bruin that gave discretion. Isn't that correct?
Yes, and I think we did have that here.
You know, it does seem to me that, you know, on a first glance, his, you know, you say his conduct is protected by the Second Amendment. I mean, we're not arguing that the Second Amendment isn't at issue in this case, but you're not saying he has an absolute Second Amendment right to carry a firearm either into the police station or in the vehicle under any and all circumstances, are you?
The Supreme Court in Bruin made it very clear that that the right is a fundamental right, but it is subject to reasonably defined restrictions. So that's very clear. Obviously, there can be restrictions on manner of carrying a firearm, certain places.
Things they allowed, I guess the language from Bruin, is it something like, you know, felon in possession statutes are presumptively constitutional They repeat that. I guess it starts in Heller. It's repeated in McDonald. It's repeated in Bruin. I think 6 justices in Rahimi said the same thing. I mean, we're not litigating the constitutionality of the first conviction, right? It's the constitutionality of this second one, which is a felon in possession statute. So why don't Heller, McDonald, Bruin, and Rahimi squarely answer that question?
When you have, first of all, those particular cases, none of them addressed criminal behavior. There was all licensing or other ways, so they didn't address criminal behavior. Rahimi addressed a finding specifically on that defendant and all of the defendants similarly situated of dangerousness. This case is, I think even this court recognized in Woods, different because it's a categorical. And although the case law, I think the Supreme Court makes fairly clear that you can have some restrictions, I bring up his underlying conviction because the underlying conviction is now and was then just not ruled constitutionally protected. So it's not, I think that it's a difference because he's not a convicted violent felon.
Challenge or a facial challenge?
Challenge, mostly because of that, that reasoning.
Served here?
So in the motion to dismiss hearing, both the prosecutor, the court, and the defense attorney talked about, yes, we do want to do an as-applied,
To dismiss hearings. There's one where, Mr. Mahana represented himself pretty ably, I would say. And then there's a second hearing where the lawyer goes in and takes another crack at it. It seems to me maybe more clear that it's as applied in the hearing where Mr. Mahana represented himself. Am I?
I think when the lawyer got involved, the lawyer took it into a little bit of a different, I think they argued about whether or not he knew, because he did seem a little bit surprised when he got a phone call when he was talking to the sheriff that he wasn't allowed because he had not been convicted of a felony. So I think the second hearing went off in that direction a little bit, and they did present that argument to the court. And
As applied challenge. So we've got in the record below that was presented on the motions to dismiss, we've got some videos, we've got some statements and representations that Mr. Mahana made. Can we consider all of those sorts of things?
Well, if we had if the statute under which he's disarmed was encompassed all of that, I think then you could, and I think even the court below, when they were discussing those videos that I think were mostly put in his bond review, but I can't remember for sure, but those videos that he had posted online, the court was like, well, I don't think that's really that relevant to this issue. I think that if it were a situation, and we're in uncharted territory as far as how this is going to end up, but if the statute said you could look at all his background and his personal life and things he says, and a lot of that's First Amendment protected, so I think we have to be careful there.
Look at all this material for what? For what purpose? What is it you're trying to prove that you think exempts him from the operation of the statute?
I'm sorry, you look at which,
What is this evidence relevant to? Like, what is the fact that you're trying to establish or that needs to be established for you to prevail on the constitutional claim that he's not dangerous? Is that it?
I was just answering the question about the videos. I don't think that they're relevant. I think they're constantly First Amendment protected material and shouldn't not be considered. I'm not saying that in some other statutory scheme or some other constitutional analysis it could be if it wasn't individualized analysis based on that. My argument here is that the felon in possession as it applies to Mr. Mahana, because he was convicted of a misdemeanor nonviolent constitutionally protected act that forever bars him from owning or possessing a
I understand the misdemeanor part of it, and maybe that shouldn't be defined as a felony, but it's really the nonviolent part of it. Is that kind of what the gist of this is? Is that if you are convicted of a felony that's nonviolent, that shouldn't dispossess you constitutionally under the Second Amendment from possessing a gun?
I think, I don't know that I have all the answers to how this should end up looking like, but when we look at categorization and labels, basically, this is putting a label on felons, and we can define the felon any way we want. That's up to the legislature, and
It seems to me, you're not saying that categorically Iowa's felon in possession law is unconstitutional. You're saying it's unconstitutional as applied to Mr. Mahana because his prior felony, and you described the circumstances, there was a traffic stop where he had a firearm and he was convicted of an offense that that the legislature has since repealed the statute, so it would no longer be a crime today. So you want to get into those specific facts. But if you're going to get into those specific facts, why is it, as you know, relevant to the dangerousness determination that the Supreme Court suggests we may have to make in Rahimi? Why not get into all the other facts? Why not get into what else is in the record? His videos, the fact that he, while all this was going on, he took a claw hammer to somebody else's vehicle and did $10,000 worth of damage, and he was awaiting sentencing for that, and some of the other things that are in the record. Why can't we consider those things?
that's, I mean, he's disarmed currently because of the fact of his conviction and nothing else. That wasn't how it came to be. I mean, that wasn't the analysis below. I mean, if this court were to find that that's what we do have to do, is the analysis of behavior or the kind of crime, then
He was, he was disarmed for a specific legal reason, but then the court goes into a long description of, basically what a dangerous fellow he is, and seems to view all of that as relevant, right?
finding below, I mean, I can see where I think there has been cases where the court has remanded for another hearing, because obviously this is a very newly developed, every day there's a new case and a new analysis about it, and if that is, we want to do a particularized assessment of each defendant's, which wasn't, how it works, so that wasn't done here.
Majority of the circuits that just take a categorical approach and say, if you're a convicted felon, then the felon in possession statutes are fine.
Well, all of those, I guess. Well, they're based on a couple of things. One is that historically we've disarmed categories of people, such as former slaves, loyalists, Catholics, Quakers, and all of that. That is, to me, incongruous to being a felon, because a felon is a label. It's not who you are.
Yes, so let's take it away from these facts, which are a little bit complicated because the prior statute was repealed. But let's just say you had a theft conviction, okay? Bad check writing. And it rose to the level of a C felony, $10,000 or more, or a D felony, over $1,000. I take it your position is that would not be a reason, or you could not then have a subsequent felon in possession statute or conviction based on this prior theft offense because it's not dangerous. Is that right?
Yeah, I think that makes sense, and the reason I say that is because historically, the felonies were the worst of the worst crimes. And today, I mean, things do change in societies. Wow.
I don't understand the premise of the argument. So if somebody writes a bad check over $10,000 and they're convicted for this C felony, they can go to prison for 10 years, right? Mm-hmm. Is that correct? Okay. And that's a deprivation of a fundamental liberty interest, right, and freedom of movement. And they lose the right to vote. Is that correct? And that's a deprivation of a fundamental right. Is that right?
I think so. I've not looked up if voting is a fundamental right.
It's a fundamental right. So you can commit a theft and be deprived of a whole host of fundamental rights, including your liberty, your right to vote. You can lose your licenses, et cetera. But why can't one of those consequences of conviction be you also lose your fundamental right to carry a firearm? What makes that right uniquely paramount to all other fundamental rights that it can never be divested?
Analogous to your right to assemble, your right to free speech. We don't take free speech rights away from people forever because they're convicted of a felony, and we don't permanently deprive people of their liberty. They're deprived of their liberty while they are in prison, but they can get that right. They can never get their Second Amendment rights, and the Second Amendment is not a lesser right, a lesser fundamental right than your First Amendment or your Fourth Amendment rights.
More. I mean, it seems odd to say. It seems odd to say I could deprive you of the right to own a gun as the state by putting you in prison for 10 years, but I can't dispossess you from owning a firearm during that same 10-year period if you're not in prison. How can that be right?
That could be right, but that's not a permanent disarmament of somebody. That's, I mean, we're talking about they can never own a firearm, and that is not equal to the other liberties and fundamental rights that we temporarily take away. And if you wanted to temporarily take away a Second Amendment right for a nonviolent person while they're on probation, parole, or incarcerated or what have you, obviously those can be more narrowly tailored, as Bruin explains. So I think my time is up. Thank you.
Be back in a few minutes. Ms. Brooks.
May it please the court. Opposing counsel. Both the state and federal constitution recognize a fundamental right to keep and bear arms. Neither constitution, however, demands an absolute right. Iowa Code Section 724.26, like its federal counterpart, 922G1, prohibits a person who's been convicted of a felony from knowingly possessing a firearm. Also, like its federal counterpart, whether the predicate crime is a felony for purposes of the firearm prohibition turns on the seriousness of the crime. For crimes committed in Iowa, Section 724.25 explains that that means Class D felonies and above, and only those aggravated misdemeanors that involve a firearm. I want to jump into the conversation about what facts we can and cannot consider in these types of challenges. Beginning with the Second Amendment, as this court has pointed out in questioning just a bit ago, the majority of circuits have adopted this categorical approach. And that doesn't mean that a defendant can't make an as-applied challenge. It means that whatever factual circumstances they put in front of that challenge, the circuit courts have determined there is a history and tradition that justifies that regulation. Now, admittedly, there is the Third Circuit and the Fifth Circuit that has delved into the person-by-person, the category-by-category, the felony-by-felony litigation. Importantly, with the Third Circuit, this was a pre-enforcement challenge. So Mr. Range sought a civil suit before he had violated a federal prohibition law. He was convicted in the late 1990s. He led a law-abiding life. He went to purchase a firearm, realized he couldn't. Once he learned of his status, he did have a firearm that his wife had purchased for him, but he got rid of that firearm. And then later he filed a civil suit seeking to enjoin the government from enforcing his rights, the firearm prohibition against him. In Range, the court went factor by factor. They looked at all of his circumstances. They looked at the predicate offense. They looked at his other offenses, which in his case were largely none. The court in that case determined that in those factors, we can look at the whole person. We can look at the predicate offense. We can look at what happened between that conviction and possessing the firearm. Similarly, in the Sixth Circuit, although they have a categorical approach, the Sixth Circuit in Williams has acknowledged that a categorical prohibition is appropriate so long as there's an opportunity for restoration. And in that opportunity for restoration, at least under federal scheme, there haven't been a right of restoration avenue because it hasn't been federally funded. That has since changed after Williams. Additionally, Williams acknowledged that they had the option to come to the court and look at all of the circumstances of that individual.
Does the categorical approach play into 1A, where we have a different standard?
So with the strict scrutiny constitutional amendment, Iowa's not alone in having that, Missouri, as well as Louisiana, and as well as Alabama. Now, I recognize I haven't been able to find any cases in Alabama, but from Missouri and Louisiana, they look at the person. They look at circumstances other than the predicate offense. So yes, they do consider the predicate offense, but they're looking at circumstances of the whole person. So yes, the state has a compelling interest in choosing certain crimes that the state views as serious enough to incarcerate them to prison for 2 years. Specifically with aggravated misdemeanors, the state has said this is serious enough for an aggravated misdemeanor when it involves a firearm that we're going to prohibit you from having one. But there are options for restoration. You can seek an application for restoration of rights, you can seek a pardon, or you go to court and have seek a declaratory order or seek to enjoin the state. And in those cases, the Missouri Supreme Court as well as the Louisiana Supreme Court walks through the factors of, well, how did the state draw this line?
Kind of evidentiary issue. So we have a new constitutional amendment that declares a right to keep and bear arms, and it says it's a fundamental right. Where do we look to determine the scope and content of that right?
Yes, I think taking some language from at least what the circuit courts have kind of talked about with the scope of the right, I think we look to the laws of the state around the time of the enactment. And this court recognized that in NS as well, is that we look to the laws on the books at the time of the enactment.
Bruin kind of flips it, and they talk about not the scope of the right, but historical justifications that would allow infringement of the right. But they say you look at the laws on the books at the time of enactment. So at the time 1A is adopted, we have all of these laws on the books. If we're doing a Bruin-type analysis, doesn't that define the permissible scope of regulation? I mean, shouldn't those laws be presumed constitutional if we're doing kind of a Bruin-type historical justification analysis at the time of adoption? Or do we look at other states' laws? I don't know.
The first part is correct, at least, that we look at the laws on the books because the right is kind of defined by the social understanding of that right when we adopted it. That's not to say that all the laws on the books all of a sudden get a rubber stamp and there's no judicial review and there's no oversight on that judgment. But to understand what Iowans understood to be the scope of that right, we look to the laws that are on the books at the time that the law was enacted.
I mean, so you're kind of, it seems to me you're kind of having it both ways. I mean, are those laws, you know, do we not worry about this particular law and just say, well, it was on the books in 2022 and therefore it passes strict scrutiny? Or do we conduct a review? What do we do?
I don't think this court gets to rubber stamp the laws that the legislature passed, and there doesn't need to be any further inquiry. I think when we're...
Inquiry.
Yes, I think, at least in the circuit courts, we talk about what kind of that relevant period of inquiry is. Is it founding? Is it revolution? Is it, when the 14th Amendment was adopted, and we can decide when that period is. I think we're in that period right now for the Article 1, Section 1A. And so it's understanding in that process of what laws are being passed, what are being repealed, what that process looks like.
It's under 1A, where it's strict scrutiny. What do we do with the fact that the underlying crime, aggravated misdemeanor, that crime was subsequently repealed, or that statute was repealed?
And I didn't read the arguments below at the district court. I didn't read the district court's decision. And I didn't read the arguments on appeal to say that the predicate offense, that anyone's challenging the constitutionality of that offense. With that being said, I think we can understand, and it's Justice Barrett's concurrence in Rahimi that discusses that to assume that we repealed the law means that we're now maximally exercising our authority isn't the correct assumption. So to look at only those that were enacted at the time, and assuming that's the ceiling, that would be a mistake, because that would assume the legislatures at the time of the Second Amendment exercised their authority to the fullest extent. So
Ideas, I'm looking for a framework for 1A. I mean, we're really, kind of, this is a case where we're really probably going to really have to apply this constitutional amendment. And so what do we do? First of all, I mean, do we apply our normal strict scrutiny and say there has to be a compelling interest? It has to be the least restrictive means necessary? And then if we do that, my second question is, do we look at all of the evidence of Mr. Mahana that's in front of the court, or do we just consider the crime that he's currently charged with and the predicate crime from 2018?
I think guidance from Missouri and Louisiana can help us on that question. I think that we have a general understanding of what strict scrutiny is, which is compelling government interest, narrowly tailored. And the case law, at least at Louisiana, Missouri, we traditionally see that language of it doesn't have to be perfectly tailored. Having other conceivable options doesn't mean that it's not narrowly tailored. But looking at Missouri, for example, the factors they looked at was is this discrete? Does it apply to, they looked at certain exceptions. They said that it's narrow because it doesn't apply to cases that have been pardoned or expunged. That's the same with Iowa.
Let's back up. Here you have Mr. Mahana. He says this was his pitch to the district court when he was pro se, and like I said, I think he did a pretty good job of handling himself. He says, well, all right, I was convicted in 2018 of peaceful possession of a firearm. I am now being convicted of peaceful possession of a firearm. And why is that? Why is that either of those things necessary? What's the compelling state interest in disarming Mr. Mahana under those circumstances?
And I want to unpack a couple of the factual statements in that question too. But answering your question first, I think that we get to look at the predicate offense and why the legislature believed that was necessary, how the seriousness of the offense. In addition to the conduct, I believe beyond just the predicate offense, but in particular, Mr. Mahana's conduct in this case. And in NS, this court said it would be a perverse incentive to look at unlawful possession of a firearm as evidence of being able to lawfully possess it. So having someone who knows that they are prohibited, who just talked to the officer that morning.
To my mind, you keep giving me kind of, snippets or sound bites, and I'm looking for a framework. What's the compelling state interest in disarming Mr. Mahana here?
The state interest in disarming Mr. Mahana is preventing firearm violence, protecting the public safety from those that are likely to misuse a firearm. Mr. Mahana's aggravated misdemeanor involved a firearm. It involved a misuse of a firearm. He didn't have a permit at the time. Now, in going forward, he has committed additional crimes, and that instead of challenging the law in action with a civil action to seek a declaratory order or to enjoin, or a pardon or a restoration of rights, he brings his firearm to the police station. And this court talked in NS about how it would be an interesting, it'd be a perverse incentive to have an individual that possesses a firearm illegally and doing so could support restoration of their rights. And so this court reasonably concluded that possessing and using firearms cuts against the restoration of rights there. So
It's compelling interest in permanently disarming somebody where the underlying conviction was repealed and is no longer a crime and did not involve using a firearm to commit another crime.
Is still valid. His conviction has not been vacated. It has not been expunged. If Mr. Mahana had concerns about the constitutionality about the underlying predicate, he has avenues to challenge the constitutionality of that offense, to remove the restriction, to expunge the case, to have it pardoned, to have his rights restored. But simply going out and affirmatively committing additional crimes is not evidence of someone being able to possess a firearm.
Conduct here that would qualify under 724.25 or 26 than that 2017 conviction?
At the time of the possession at the police station? I don't believe so. My understanding from his criminal history is that he had a deferred judgment that was, he had a conviction for domestic abuse that was deferred. That being said, he had served his probation for that term, and so it couldn't be a predicate, but I don't think that should remove it from the consideration of the facts underlying that conviction. So the predicate offense in this case for the felon in possession is the carrying weapons.
You think we should still think about that in terms of evaluating his dangerousness or something else?
I do think that it is important to look at the entire individual, and I want to specifically call out I believe it's Louisiana, but yeah, it was State v. Eberhardt, and in that case, the individuals had their predicate offenses, they committed additional crimes, and in that case, it said those defendants illustrate, rather than show the exceptions to, the principles underlying the laws, that certain individuals convicted of certain crimes are going to have a higher likelihood of committing additional crimes. And so I think evidence of his further criminal activity, if this court doesn't want to consider it as like positive affirmative evidence of his dangerousness, at minimum, it shows that the legislature, in picking that category that he was originally convicted of, he's the right type of individual to be covered, because he then did go on and commit additional crimes, which is exactly the concern that the legislature had for prohibiting people that have misused firearms from them possessing them again. And very quickly, I do want to point out this permanent temporary distinction. And I do think, so the Eighth Circuit in Brown has discussed that it is permanent, but there are options for restoration. Although not required, there are options for restoration. And here, Mr. Mahana had, by my count, 4 options. And he chose the 5th, which is going out and committing an additional crime by bringing a firearm that he knew he could not possess to a police station, only to then use it as an affirmative defense to say, hey, that shouldn't have prohibited me in the first place. For those reasons, the state asks that this court affirm both on the Second Amendment.
I just want to see if I'm following what your argument is in response to Justice Mansfield's request for kind of a framework of how we look at this. So it's kind of your position that if someone violates 724-26 by knowingly possessing a firearm when they already have a felony, then we don't really look beyond that, because they could have taken legal methods to have be able to possess their firearm. Is that kind of what you're saying?
I think what I'm saying is that there is in no world that he cannot challenge it in this case, but the best case for him, the most likely opportunity to say, hey, I am law-abiding and I am able to have this firearm and do so lawfully, is not by committing an additional offense. So it's not that...
But he didn't do that. So can you just try one more time with the framework of kind of what the strict scrutiny test looks like?
So and I'm sorry if I'm being unclear on this, but at least my understanding from the Missouri courts and as well as Louisiana is we're looking at the predicate offense, we're looking at all of the other conduct, and we're looking at the other criminal activity that they've done as well. We're looking at the whole person. We're also looking at the law, and what did the law capture and what did it not capture? In Missouri, for example, it captured only felons. There's no problem if it's violent or nonviolent. It didn't have an avenue for example, Louisiana doesn't have an avenue for restoration beyond a pardon. But that's narrowly tailored. So the courts are looking at where is the state line drawing, and here the state drew the line at only felonies and only those crimes that are punishable by a carceral sentence of 2 years that involve a firearm. So it's not all misdemeanors, it's not all indictable offenses, it's not. So I think it considers both the regulation, the law itself, but also the individual's characteristics, background for this type of challenge.
Fact that this particular crime, his predicate involved a firearm, is appropriate for drawing the narrow tailoring line, in your view. So do we need to look at, I guess my confusion is, how does that play into his other evidence about his general dangerousness? Or are we just looking at that predicate, or we look at that to see if they've drawn the line in the right place as far as it being narrowly tailored, but then we can also look at whether or not he's otherwise dangerous?
I think what is most persuasive to me is the Louisiana court's discussion on when we look at that the additional offenses, it's saying that, hey, this was This was the conduct the legislature was concerned about, is that people that have been convicted of certain categories of crimes are going to go on to commit more crimes, eventually with violence, eventually with firearms. And it's using that evidence to say, and this individual who was covered by that law did in fact go out and do additional crimes.
Final question, I hope. Yeah. Same predicate offense, but someone who doesn't otherwise commit any other, no violent history, but still brings their gun into the police station when someone calls them and says, hey, by the way, your felony prevents you from carrying a gun. Does that change your analysis?
Closer call, but I don't think it moves the needle for me. And it's because when we look at the conduct of this second crime, the 724-26, this individual had a long conversation, or well, rather short, I guess, but a contentious conversation with the officer on the phone. He then went to an eye clinic. He called dispatch and said, I'm at this eye clinic. I'm armed. Come arrest me. Law enforcement put out a notice and said, Mr. Mahana is armed and looking for a confrontation. Within a couple hours, he shows up at the police station with a firearm. So I think if this court were to cabinet to only the facts of the predicate and this conviction, I think we still meet our burden here. So if there are no further questions, the state asks this court to please affirm on the Second Amendment and Article 1, Section 1A. Thank you.
Thank you. Just a point of clarification, I'm not sure it's going to make a big difference, but just factually, he was charged with 2 counts in this case. I went back and looked at the trial information, and the count that was not dismissed, which is the count we're here today, on the date of occurrence of that was not in the police station on December 5th, 2022. It was actually charged in the May 27th, 2022 situation at a park when...
No?
In front of me, I wish I did, but I looked at that the other day. I've looked at a lot of things in the last couple of days, but I don't know if that's a distinction, but if you're going to look at his conduct and all of that, I think it might make a difference. But the factual...
Field looks that up. Can I ask you a question? And I think you'll get back to it in a second. And it's focused on the text of Article 1A, which doesn't provide that any law involving a gun is subject to strict scrutiny. It says, any and all restrictions of this right shall be subject to strict scrutiny, which I guess raises a prior question of what does this right mean? So where do we look to determine the scope and content of the right prior to determining whether a law is a restriction on that right?
You're talking about the Iowa Constitution, that section, yeah. Well, the amendment says you apply strict scrutiny. I think, you mean before that, the right itself?
It doesn't say, like, it's not strict scrutiny floating in the air, and anytime something involves a gun, strict scrutiny applies. It says strict scrutiny applies to a restriction of this right. So before we can determine whether or not a law restricts the right, we have to know the scope and the content of the right. And since this is a brand new amendment, where do we look to determine the scope and content of the right?
Is the people to keep and bear arms shall not be infringed, and I think that's very similar to Second Amendment language.
Is the right of non-felons. I mean, what if the scope of the right to bear arms does not include felons? How do we make that determination? Where do we look?
Well,
It seems to me, if you said we should look to what federal courts are doing, what Bruin says is you look at the state of the law at the time the amendment was enacted, and whatever was on the books at that time provides historical justification for future laws. So we are at the time of the founding, so to speak, in terms of Article 1A. So why don't I look at the laws on the books at the time 1A was adopted and say, this is the universe of permissible regulation, and any further restrictions are subject to strict scrutiny, but these laws define the scope and content of the right. Isn't that a Bruin-like analysis of 1A?
Well, in Bruin, the first step was, does it apply to the people? Does the amendment apply to the people? And I think that when Bruin went away from strict scrutiny into the historical analysis, I suppose we look at the historical analysis of what the people are and what the Iowa tradition of conferring rights of the people are now. I mean, in this particular case, with the time that law was enacted, the crime my client committed was no longer a crime.
Oh, here's, I mean, another way to look at, there's clearly a difference between Section 1A, Article 1, Section 1A, and the Second Amendment. And these are new cases for us, and we're grappling with it. It does seem to me that the Supreme Court says on the Second Amendment, you have a right to bear arms. Restrictions, to see what restrictions are permissible, you look at historical analogs. You don't do a means-ends analysis. You don't do rational basis, strict scrutiny, anything like that. The people of Iowa have adopted, it seems to me, a different approach, and that is you have a right to bear arms, and to determine what restrictions are appropriate, you do a means-ends approach. You don't necessarily look at history. You look at strict scrutiny, and is that met or not?
Interpret it, when I read Bruin, and they specifically said they disavowed the means-ends tests that the courts had been using and then replaced it with the historical analysis that had been under the surface but trying to work into this different test. In the meantime, when that was happening, Iowa said, we're doing strict scrutiny, and I think that's actually a harder test to pass. And, but that's the test that we have, and I guess it's...
Under 1A, strict scrutiny means ends analysis, what do we do with the fact that the underlying crime, that statute was repealed?
Kind of what was discussed earlier about, do we presume that when, they passed it, that the crimes were constitutional or okay? I don't know if that's the correct analysis or not, but specifically this crime was not there. So it doesn't pass any test under that analysis. And I would just ask the court to look at what the district court decided below, and if we want to, it stopped at whether it applied at all. And if there's further analysis, I'd ask the court remand for further factual findings about dangerousness. Thank you.
The case of State versus Mahana is hereby submitted.